we all on? Okay. This is a special meeting of the Sunshine Ordinance Task Force called to order at 4:21 on August 26th, 2014. Mr. Young, would you call the roll, please?
Item number 1, call the roll. Call to order and roll call. Member Rummold.
Present.
Rummold present. Member Winston.
Present.
Winston present. Member Wolf.
Present.
Wolf present. Member Pilpill. Pilpill absent. Member Hepner. Hepner absent. Member David. David absent. Member Fisher. Fisher absent. Member Oka.
Present.
Oka present. Vice Chair Hyland.
Present.
Hyland present. Chair Washburn.
Present.
Washburn present. We have a quorum. I do not have any agenda changes on today's on the agenda.
All right.
Item number 2, file number 13090, complaint filed by Jing M. Louie against Frank Lee, Department of Public Works, for allegedly violating Sunshine Ordinance Section 67.21B and 67.25A for failure to respond to immediate disclosure requests in a timely and complete manner. Madam Chair, for your information, I have contacted I tried to contact Mr. Louie several times, both by voicemail, phone calls, and emails, and I have not received a response. Mr. Louie has received many documents from the Department of Public Works, but I do not believe he's in the room. I do not believe he intends to attend today.
All right. I believe we should perhaps continue this to the call of the chair.
May we file this, and then if he wishes to reopen it, we can do it at that time.
Okay. What is the could you remind me of the procedure?
Mr. Lee is here. He can speak to it if you would like.
Should we wait? I need some help with the procedure here. This doesn't happen very often. So should we find jurisdiction and then hear from the respondent? We usually don't do that because the complainant's not here. So, Member Wolf.
Through the chair to Victor, when was the complainant first notified that today was the day that he was supposed to appear and hasn't returned any of those communications?
I do not have an exact date, but approximately 2 weeks or more.
And that was, you said you notified him by email, phone, and...
I've been trying to contact Mr. Louie for the past 6 months to try to get him to either withdraw or to take some action with his complaint. This has been scheduled before in the past, and he did not appear at that time either. So I cannot file it, so I placed it back on the agenda with the rest of the Public Works item. I hope that we could file this item due to non-responsiveness from the complainant.
That sounds like a good idea. So how do we make that happen right now and follow Robert's rules? Need we find jurisdiction?
I do not see any harm in finding jurisdiction and then filing it.
Okay. All right. Do I have a motion to find jurisdiction in this matter?
Moved. Second.
Is there any public comment on this? Seeing none, without objection, we find jurisdiction. So at this time, I'd like just to hear Mr. Lee is here. If you would just update us on what has transpired between you and Mr. Louie most recently.
I think you'll find, this is Frank Lee, Department of Public Works. I think you'll find in your package that I did respond to Victor's email to let you know that we did respond to Mr. Louie way back in December 13, 2013. And we provided him with over 2,000 pages of documentation, and he just hasn't responded since then.
All right. Is there anyone here that has anything else to say on this matter? Okay, seeing none, do I hear a motion to conclude this? Or is there any public comment? Okay. First, do I have a motion to
So moved. Second.
Okay. Is there any public comment on concluding this matter? Okay. Without objection? Okay. Victor, would you call the next item on the agenda, please?
Item number 4, file number 14062, complaint filed by Jonathan Germain against Edward Lopez, Paul Travis, and Frank Lee, Department of Public Works, for allegedly violating Sunshine Ordinance Section 67.21B, 67.24, 67.25A, and 67.34 for failure to respond to requests for public records in a timely and complete manner on April 30th, 2014, and an immediate disclosure request on June 9th, 2014.
All right. First, we have to find jurisdiction. Has jurisdiction been contested? All right. Do I have a motion to find jurisdiction?
Ed? So moved.
Second.
Okay. Is there public comment on this matter? Seeing none, without objection, we find jurisdiction. Okay. At this time, Mr. Germain is here.
Yes.
And the way this works is you have up to 5 minutes to, we have quite a bit of material here, but just a brief summary and then bring us up to date.
Okay.
And then we'll hear from the Department of Public Works, and we'll have questions for you undoubtedly. So you have up to 5 minutes.
Okay. Okay, so my complaint has two parts. If you look at the document that I submitted via email to the SOTF email address, the first part of the complaint is the simplest part. On April 30th of 2014, I made a request for all documents regarding the 2111-2115 Jennings Street project to Edgar Lopez, Paul Travis, and other employees of the Department of Public Works, with the note that I had seen an email from another city employee saying that they were working on the project. In response, on May 2nd, the Department of Public Works responded, 1, that it had no responsive documents, and 2, that Mr. Lopez was not working on the project. They made that statement specifically. If you look at attachment A of the documentation packet that I submitted, you'll see an email from Dan Sider of the Planning Department to Mr. Lopez saying that they are asking Mr. Lopez to work on this project. The DPW, in their response to my Sunshine request, said this email didn't exist. Clearly, it does. So I believe that they are in violation of the Sunshine Ordinance, 1, for lying about the existence of the email, and 2, for not providing the required responsive documents, the very minimum of which would be the email that's there in attachment A. Now, the second part of the complaint is slightly more complex. On June 9th, I made an immediate disclosure Sunshine request for the same set of, the same documents regarding the 2111-2115 Jennings Street project. The Department of Public Works responded that it had some documents, but it was withholding them under Section 67.24A2 and 67.24E1 of the Sunshine Ordinance. Let me address Section 67.24E1 first. That section is intended to allow the city to keep the bids of private contractors secret during the bidding process. So if DPW had put out an RFP for work on this project and had gotten a bunch of bids from private contractors, then they would be entitled to keep those secret. That's not the case here. DPW has not put out an RFP and is not collecting bids from private contractors. What they're doing is they claim that the Department of Human Services, another city department, has asked them to bid on a project, and that these communications are exempt from disclosure because of that. If you look at the language of the law, 67.24E1, it says that contracts, contractors' bids, and response to requests for proposals and other records of communications between the department and persons or firms seeking contracts shall be open to inspection after a contract has been awarded. The law is specific that it refers to communications between a department, and persons or firms seeking contracts. Here, the department is the Department of Public Works, and there are not persons or firms seeking contracts. What my request refers to is communications between different city departments. Like I said, if DPW was conducting an RFP and getting bids from outside contractors, this would apply, but it does not apply to communications between different city departments. Now, let me address Section 67.24A2. Section 67.24A2 allows a department to keep confidential draft versions of an agreement negotiated between representatives of the city and some other party. DPW is negotiating an agreement with the Department of Human Services. So it's one group of city employees negotiating an agreement with another group of city employees. The law lets them exempt material from negotiations with another party, but there is no other party. It's the right hand of the city negotiating with the left hand of the city. So there's no exemption here. Since those exemptions don't apply, I believe that DPW is in violation of the Sunshine Act. And that's my conclusion.
Okay, thank you. We'll have some questions undoubtedly for you in a few minutes. Is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none. A representative for the respondent, DPW? Mr. Lee, you're... Okay, thank you.
Frankly, Department of Public Works. I like to say the Department of Public Works provide project management, architectural design, engineering, and construction management services to all city agencies. However, Public Works does not provide these services for free. We provide these services at a cost and have contracts in place with departments for such services. Public Works, however, does not have a monopoly on these services. Departments do not need to hire Public Works for any of their projects. They can go outside and hire somebody else. It's been known that some of the branch libraries, the fire station, playgrounds have been designed and constructed without Public Works involvement in all phases. When Human Services Agency approached our department and asked us to submit a proposal for services, they supplied us with a copy of a proposal from Tom Elliott Fish Architects. The complainant has a copy of that proposal as well. So therefore, we felt that we were supposed to submit a competing proposal. At the same time, we did not know if that Human Services Agency would be asking or have asked any other firms or any other entity to provide services or a proposal for them. Therefore, in our response to Mr. Germain, we informed him that we were going to withhold these documents related to the creation of the proposal, the contract, until HSA Human Services either accepts the contract, either from us or from another entity, or when HSA releases it for public review. So we cited those two sections that Mr. Germain mentioned. 67.24A2 says draft versions of an agreement being negotiated need not be disclosed immediately upon creation, but must be preserved and made available for public review. It further states that if the negotiation of a contract in which an agency of the city is offering services in direct competition with other entities that are not required to make their competing proposals public access to the draft agreement could be postponed. 67.24E1 says contracts, proposals, and all other recorded communications between the department and persons or firms seeking contracts shall be open to inspection immediately after a contract has been awarded. In this case, Public Works identified itself as a firm seeking a contract with HSA. The proposal that Public Works submitted to HSA is not a simple 1 or 2 page proposal. It's a 36-page document detailing exactly what services our department would provide, how we would approach the project, and our fees. If this information was released to the public or to a competitor, we would be at a disadvantage. There was nothing evil about withholding these documents. We just felt that we didn't want our department to miss out on an opportunity for work for our employees. So we informed Mr. Germain about this. We told him that we would release all our records prior to May 14th, 2014. That was the day of our staff's first site visit. We told Mr. Germain that we would withhold the records from May 15th, 2014 to June 13th, 2014, because between those 2 dates was when we were preparing the proposals. And on June 13th, we submitted that proposal to Human Services Agency. As of today, HSA has not accepted our contract, and frankly, I do not know what their plans are going forward. Mr. Germain, yes, to submit 5 records requests to our department. We answered them. We provided details of why we were withholding documents and why we were releasing some to him. And that's the conclusion of my presentation.
Thank you. Is there anyone here to offer facts and evidence in support of the respondent? All right. Seeing none, the matter is with the task force members for further questions. Member Wolf.
Mr. Lee, can I ask you a quick question? Yes. So in explaining the narrative, I still a little unclear. So the proposal you sent to HSA hasn't responded.
That's correct.
And until HSA responds, you're maintaining that as a not public record? Is that?
That's correct.
And if HSA were to never respond, is there some point that that proposal ceases to be active and defaults into?
Well, you need to, I suppose you could ask HSA because that's they can release it. I mean, the Sunshine Ordinance actually says that they can release it for public review. So I don't know.
But if HSA does nothing and 10 years from now, someone wants this document, clearly it's no longer meaningful and it should be, there's no reason why it shouldn't be publicly accessible because the contract's not going to happen 10 years from now. But it sounds like you're saying that unless HSA opens it up, your hands are tied from your perspective.
Yes, I think so. But
okay. Thank you.
That's my opinion.
I have another question for you, Mr. Lee. So it seems like in order for 6724B2 to apply, there has to be direct competition in a bidding process. And I was wondering if, I know you hinted at the fact that you thought that other firms' submission was in fact some type of, some type of proposal. But do you understand there to be a directly competitive process going on about the...
I do not know.
Okay, well, I mean, so for that exemption to apply, there has to be a directly competitive.
Well, we feel that there is, especially if somebody gave us a competing proposal and say, can you beat this or can you do better than this? Can you give me something counter to this?
So, and then, so I'll read that part of the exemption, right? In the case of negotiations for a contract lease or other business agreement in which an agency of this city is offering to provide facilities or services in direct competition with other public or private entities that are not required by law to make their competing proposals public or do not in fact make their proposals public. The competing proposal is public, right? So why...
I do not know that. I mean, Tom Elliott Fish Architect, we were given that proposal. I mean, we didn't go ask for it. It was given to us.
Right. But it is public now, right?
But I mean, I would assume it would be Human Services Agency's prerogative to release what they have.
Right. Okay. Thanks.
I have a question for Mr. Germain.
Yes.
I'm wondering, have you gone to HSA and asked for copies of these bids?
I did go to HSA and get a copy of DPW's proposal. What I don't have is the notes from their architects, the miscellaneous communications between different DPW employees, and the miscellaneous communications between DPW employees, HSA employees, and other city employees. So the HSA did give a copy of the proposal itself, but I don't have the miscellaneous emails and communications between the different city employees that are associated with it. I should also note, if I can, that I have an email, it's an attachment B of the documentation packet from David Curto, who is the Director of Contracts at HSA. And it says, the Phase 1 environmental report is being handled by DPW and should be underway as we speak. That was June 12, 2014. So I don't know whether whether HSA has issued a letter saying that DPW will work on this project, but as of June 12, 2014, they already had begun doing work. Even if no letter has been issued, it's a de facto they're working on the project.
When you say they are working on the project, you mean DPW is working on the project?
DPW is, yes.
It's working on the project at HSA. So there was a bidding process. There was their bid and this other architect.
No, DPW was the only bid. HSA solicited a bid from an outside architect, years before, and passed that bid to DPW to assist them in knowing what to put down. But DPW is the only bid on HSA's request.
All right.
And you can see from attachment B that HSA says that DPW has begun work on this project.
Member Rummold.
So if I understand right, the records that are outstanding for your request here, now that you've gotten the proposal, the only outstanding records are communications about the project.
Exactly. Communications between DPW employees, between other city employees, and so on about the project.
Okay.
Member Winston.
Mr. Germain, if I may ask, what's your interest in this project?
So I'm part of a Bayview-based nonprofit that's opposing it.
Which nonprofit?
Equality SF.
Thank you.
Member Wolf.
I have a question for Mr. Lee again. So apparently the proposal has been turned over from HSA, which means that that's now a public proposal. So is the communication related to the construction of that proposal still protected from your vantage point or not?
I will leave that up to the task force to decide. How's that?
If he were to submit an immediate disclosure request to you right now without us being involved, would you turn over that information?
I don't know, because I really have to see if that's accurate, that HSA has released a proposal. I don't know.
Okay.
HSA hasn't told us anything. And contrary to what Mr. Germain said, we are not working on the project.
Okay.
Okay.
Thank you.
Member or Vice Chair Hyland.
Mr. Lee, another question for you. Have you received any advice from the city attorney on this matter?
No.
Okay, thank you.
Members, do you have any further questions? Okay. At this time, Mr. Lee, you have 3 minutes to offer a rebuttal, some additional information.
No, I don't have any additional information, but we would abide by what the task force suggests.
Thank you. Mr. Germain, you now have 3 minutes
Okay.
for closing remarks.
Okay. So in responding to DPW's claim about their exemptions, one, I think it's important to note that according to the Director of Contracts for HSA, the DPW is working on this project. You have the email there in attachment B. Two, it's important to note that the exemption in Section 24E2 applies only when there is a direct competition between a city agency that's providing services and a private bidder. There is no competing private bidder, and if there were, it would be up to DPW to show it, since it is the city's responsibility to show that a record should not be released, not the public's responsibility to show that a record should be released. The onus would be on them to show it. I believe that's all.
Thank you very much.
Oh, actually, one more small item. The Sunshine Act requires that city agencies redact the minimum possible amount of information. So if there are a couple of lines or a paragraph or half a page that isn't exempt, then that information should be blacked out, not the entire document. The entire document should not be not submitted.
So did you receive some documents that were completely redacted?
Oh, no, it's that they're simply not giving the documents at all instead of potentially redacting material that should be redacted.
Sure, okay, I get it. All right, members?
Chair Washburn, looks like there's a member of the public that is interested in commenting. Is there-
You'll have a chance to speak when we have public comment. Yes. Member Winston.
Chair Washburn, I'm a little bit concerned with the fact that this organization appears to be a single-issue organization. I just researched their Equality SF's website, and I can't find anything else other than the homeless shelter at 2115 Jennings Avenue as on their agenda. May not be germane to the complaints, but I think we're going to hear a few more complaints about this issue in the next couple of weeks, and I think it's worth keeping in mind when we actually pay attention to this issue.
Okay, I guess we typically, and the law doesn't require us to ask why somebody wants something.
But I did ask, and I did the research, so I'm bringing it up. I think it's a very germane issue.
All right, thank you. Member Wolf?
Mark was had his head up first.
I'd just say that I think it's bad policy to weigh in on, or to even ask about why people want access to information when we should, the law looks at it in kind of a neutral way, and I think that's probably that one that we should do too.
And
Member Wolf?
I no longer need to make my statement, so.
All right. Members, do I hear a motion? Member Wolf.
I think it's unfortunate. We were talking earlier before the meeting started about how the city attorney isn't able to, our city attorney representative isn't able to make it to the special meetings. And I think that the issue of how these communications are at play in terms of this unknown situation, in terms of the contract, does seem like a question for our city legal representative. I don't really know how that should play out. We talked to the representative from DPW who said that he was deferring to us, and I just don't really have a good sense of how the law breaks down this subtle issue.
Member Rummold, do you have, as the lawyer sitting here amongst us?
I
hate to put you on the spot.
Well, so I
Trying
think
to move us along.
the fact that I'm very uncomfortable with the idea that this city agency is characterizing itself as like a private contractor, and that in its role as a private contractor, it takes itself outside of the sunshine, the rules. The fact that there was no competition for this, well, the fact that the proposal has now been made public, obviously they can't withhold the proposal anymore. That's out the window. I guess there's just a question of whether they can continue to withhold the communications, and I don't know. it might require looking into it a little bit more. I don't know if I'm ready to make a snap judgment here.
Member Highland.
From what I've heard, and in fact, I guess I've heard more cases than some of the new members of the task force, this looks pretty clear cut to me. The defendant is saying, that they would work with us, they potentially would release this information. I think we have to go on record and find a violation. We can choose which ones, and then, forward this to the next subcommittee to make sure that this information is provided to Mr. Germain. I think that's probably the course we should take, and I'm open to any motions and any parts of this, indeed all of it, that we can include. That's kind of just where I'm leaning right now. I also think it's important, given the limited number of members here, that we get it right the first time, so that we can, vote on it.
Member Wolf.
I think you make a great point, and I think beyond that, because the representative from DPW didn't actually put forward an argument as to why they shouldn't have those records, perhaps that means that we should defer to those records being made available.
Member Rummold.
Well, so they did claim that one exemption, which protects, so this E1 protects contracts, contractors' bids, responses to requests for proposals, and all other records of communications between the department and persons or firms seeking contracts shall be open to inspection immediately after a contract has been awarded, right? So that's, if they're right to characterize themselves as a contractor, as a contractor, then they can withhold it until a contract's been awarded. But I think it's just wrong to characterize a public agency as a contractor. So without some more substantial statement than we're a contractor, I think we should find that they're a city agency as usual and that it doesn't apply.
And also the fact that apparently one city agency is saying, hey, the work is proceeding. Here's the proposal.
Right.
So there is no real competitor at this point in time. So it's all happening. The file should be completely made available. Member Wolf.
I agree with what Member Rummel is saying in theory, but I feel like I don't necessarily have the full legal concept around that, and I would prefer to take a more narrow reason to provide the ruling than this element of government agencies serving as contractors, because that just feels really nebulous, and I'd rather push that off to a later point when we do have the city attorney for advice and focus on a more specific point to make that available, such as the fact that the contract itself has been turned over.
So would you like to make a motion that's
Sure.
going to hit the points you want to see?
I would like to make a motion that DPW provide the communication records as per the complaint, and that we find the violation of, can someone?
6721B.
That looks good. Yeah, 6721B.
And possibly
6725.
25A. I don't see willful. I just see more ignorance in this case. So those are the two sections that I think are applicable, in my opinion.
It seems like 6724 is a possibility. Okay.
We need to be more specific than that.
Yeah, 24A.
Or we need to be more specific in which section of 6724 is what you're saying?
Right.
You'll have a chance to speak. Yes.
Sir,
No,
please.
sir, you'll have a chance to offer public comment when the motion is made and seconded.
Right.
I'd like to offer 6724A, A1, or 67, yeah, 6724. 24A.
1 and 2.
But there's also E.
Contracts, bids, and proposals. Yep.
I think
Right.
E is appropriate.
Pardon me?
I think E is appropriate. Contracts, bids,
E,
responses.
okay, so E would do it. A as well. A is the supporting documents. Are we getting
So-
this right, Member Wolf?
Yeah, so I like both 24A and E, and I am inclined to just focus on those two violations because the other ones get into areas that feel a little bit nebulous in terms of whether they were lawfully a contractor and when that point, when they need to turn over the information would occur, whereas 6724A and E are clear violations no matter how that issue is parsed.
And I would add 6725A because it was an IDR. I think that would complete it. So 21B, 24A and E, 25A.
So Member Wolf, who started this, this is really raggedy here, guys.
I'm fine with that. Let's go with 6725A, 6724A, and E.
And
6721B was the,
And that one as well. That was the first one.
Oh.
that's withholding
Sure,
information.
fine.
I mean, that's not providing information, it's kind of generic.
Okay.
Okay, all right. So,
Perhaps
Victor, did you get all of that?
Yes, the motion is to find the Department of Public Works in violation of 67.21B, 67.25A, and 67.24A and E.
Second.
Second that.
So, all right, now is the time for public comment. You have up to 3 minutes for public comment.
I'm Patrick Minetshaw here on my own time. I want to compliment Mr. Louie on his opening presentation and his research.
Mr. Germain.
Mr. Jermaine.
Mr. Germain.
I'm sorry, Mr. Germain. That his presentation was very well researched. He clearly knows the Sunshine Ordinance. I find it relatively appalling that the Department of Public Works did not even consult their deputy city attorney.
Oh, wait a minute. We just lost quorum, so if we'll stop the clock and, okay, all right.
That's quite all right. I don't mind the lost seconds.
Apologies.
I find it kind of appalling that DPW did not even consult their deputy city attorney. And I have to agree with the feedback given to Member Winston that there's a provision in the Sunshine Ordinance that precludes city departments from asking records requesters why they want the records. By the same token, this body should not be straying anywhere near that sort of line of inquiry. Thank you.
Thank you. Is there additional public comment?
Yes, please. Sorry for my interruption earlier. My name is Charles Curtis Grisham, Jr. I wanted to comment because I think later I'll be able to point to a similarity with my complaint. 3 times that I heard Mr. Lee responded to substantive questions with "I don't know." One was whether the contract was competitive. Another one was had it been transferred. There was another one. "I don't know" was his answer. Why has DPW sent a representative who does not know and has not troubled to brief himself on the substance of this complaint, number 14062? Also, did I hear correctly? Mr. Lee denied having consulted with city attorney on this matter. I will be requesting that info from city attorney, and so I would like SOTF to ask Mr. Lee again. Did he consult with the city attorney or any of Dennis Herrera or any of Dennis Herrera's staff on this matter? If not, did Lee consult with any attorney on this matter? Did he write his statement, which he read into the record here? If not, who wrote it? There is, to my mind, the appearance of willful obfuscation, evasion, dissembling, red herring, distraction, and obstruction on the part of Mr. Lee. Here, as well as in my complaint, I'll be bringing to you a little later.
Thank you. Is there additional public comment?
Good afternoon, Task Force members. Richard Nee. Respectfully, I suggest that you consider adding to the list of violations Section 67.26 and Section 67.27.
Excuse me. Member Emeritus, could you give us your reasoning?
67.26 basically says withholding is to be kept to a minimum, and from what little part of the discussion I've heard, I think that may be relevant here. 67.27 states that when information is withheld, a written justification be provided.
Right, thank you.
Good evening, Task Force members. Thomas Piccarello. I would again urge the Task Force members, when you're proposing a motion, that you elaborate on what these violations are. You're citing 67 point whatever. It doesn't help the members of the public, nor does it help the complainant, nor does it help the respondent to tell them what your motion is seeking. So again, would ask you that if you're going to say 6725, you tell the members of the public and the respondent and the complainant what you're proposing. So then you could get some feedback. Secondly, I don't see the relevance of the status of the complainant's nonprofit, who he works for. That is not relevant, and that should not be permissible. That question should have been stricken. The complainant's status is like asking him what political party does he belong to. It's not relevant. It's not in front of you. That issue is not in front of you. The issue is he requested records and did he get them? And if he didn't get them, why not? Finally, I'm troubled by the fact that you only have 6 members here tonight. That means that anybody filing a complaint tonight has to get a unanimous decision by all of you in order to get his justice or her justice. Thank you.
Thank you. Is there additional public comment on this matter? Mr. Lee, you're not a member of the public.
On the motion?
No, you may not. Okay, at this time, is there any interest in amending the motion to include 67.26 for withholding kept to a minimum, 67.27 justification for withholding?
I'll suggest the friendly amendment to my own motion if I can do such a thing.
Okay. Does the
Second.
second approve?
Yes.
It's Mr. Member Oka. Okay. All right. Mr. Young, would you call the roll on the motion, please?
On the motion to find violation of 67.21B, 67.25A, 67.24A and E, and 67.26 and 67.27. On that motion, Member Rummel.
Aye.
Rummel, aye. Member Winston.
Aye.
Winston, aye. Member Wolf.
Aye.
Wolf, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye.
All right. What happens next is that the parties will receive an order of determination. The Department of Public Works will receive this order citing our findings and also requesting that the documents that were withheld be provided to the complainant within a very short window of time, then you will appear before the Compliance and Amendments Committee, which probably the soonest would be in about a month and a half from now. I believe it'll meet again as a CAC in October. Is that correct? Okay. And we'll hear an update at that time, hoping that all the documents are provided that we've requested that you provide. Okay.
I just wanted to clarify the documents that were withheld. Is it my understanding to mean that is concerning communications about the project at 2111 and through 2115 Jennings? I just want to be a little bit more specific.
I think you may have to work with Mr. Germain have him specify what he doesn't have.
If Mr. Germain can just provide that this time, if it's...
Could you let us know at this time the outstanding documents?
So the outstanding documents should include communications between different city employees, between different employees of DPW and employees of DPW and HSA and any other city departments. Communications with any third parties, and any written notes or notes of meetings or notes of site visits created by DPW employees.
May I ask concerning what subject?
Regarding the project at 2111, 2115 Jennings Street.
In the memorandum, there's a lot of, through the chair.
Yes.
It's quite detailed what he's looking for in the memorandum, I think. I think he's just repeating what's in there.
Right.
If you need to
His original
double-check.
request, yeah.
Right.
Okay. All right. At this...
I have the order.
Okay, wonderful. Would you call the next item for public comment, please?
Item number 3, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters as within the task force jurisdiction, but not on today's agenda.
So,
Give me one moment, please.
if you would pass these out to the task force members, Mr. Young. I'm Patrick Manette-Shaw. I received notice from the Ethics Commission that that the executive director has dismissed my second complaint against Member Pilpel regarding the August 4th complaint, which is when he appeared before the Ethics Commission on July 28th and introduced himself as a member of the public and then quickly slipped into using the third person as if he were representing the full task force. That complaint has been dismissed. The initial SIA complaint of June 22nd, I received confirmation, has not been dismissed. The document that I'm handing you tonight is the appeal that I'm going to present at the Ethics Commission's September 22nd meeting to the Ethics Commissioners, since Commissioner Keene indicated that they have a mechanism of calling back items that have been dismissed by the executive director. This document here will explain to you why I believe the case should be appealed and that the full Ethics Commission should hear both SIA complaints but against Member Pilpel. Of note, Mr. Croy cited only Section 3.A.1 in the actual SIA. He neglected to base his dismissal on Section Roman numeral 3B1, which does provide restrictions on folks like Member Pilpul that he is not to provide advice to other entities. This is not about Mr. Pilpul's First Amendment free speech rights to go to another board or commission to speak on items of interest to him as a private citizen. He is going to the Ethics Commission and holding himself out, providing them with information that falls inside the scope of his duties. The remainder of this 4-page document provides you with information that the city attorney's Sunshine and Ethics training video particularly prohibits ex parte communications. That is exactly what Mr. Pilpul is doing. He's engaging in ex parte communications, and this board, this task force, needs to seriously consider putting a stop through it by censuring Mr. Pilpul. Thank you.
Thank you. Is there additional public comment on matters not on tonight's agenda?
Hi there. At the last Compliance and Amendments meeting, the Arts Commission disobeyed a direct order. They did not come up with an inventory of meetings. They came up with a lot of babble that made no sense. It was kind of upsetting to me that it wasn't sent back to the full task force or even ethics. It was put off for a full 4 months. Nobody bothered to ask me if that was okay with me, or are you going to be around, or, and actually it's not okay with me. I have December is the busy time. I am supposed to be on the East Coast doing shows, so I'd be asking you if you can move that up. A month and a half would be good. That would be great for me. And I fully believe that by giving them yet another free pass, that it makes no difference whether it's a month and a half off or 4 months off, because they're late in posting the last visual arts meeting. They've showed no interest in even complying. So there's no indication that things will change a month and a half from now or 4 months from now. So I'd be asking you to move that case up. And then I know you have no authority in this matter. I just want to let you know that Kate Patterson, the communication person over there, still continues to send me between 5 and 20 emails a day when she could send one. And because I work out in the street, I'm dealing with a lot of things: homeless, mentally ill, tourists asking questions. And to have my phone go off constantly like that is really annoying. Actually, somebody stole a panel of my most complicated, very best earrings because my phone was going off. And that's been going on for quite some time. I've sent her emails asking, please, could you just send one email that would be comprehensive, and I don't get a response. And then the last thing, I've told you in the past that people, I would guess you call them street artists, have been retaliating on me. I don't personally know a lot of them, but there was one that was has been particularly harassing me for some 2 years, from pretty well the date I started filing sunshine complaints. I don't know him personally, but the things he's said have been very terrible. And he's also said he's doing it because I'm filing sunshine complaints. He would be the manager at Justin Herman Plaza. Last week I went to court and I got a 5-year restraining order against him. So I would like to enter this in the public record.
Thank you. Is there additional public comment?
Thomas Piccirillo. I asked the chair, what happened to item 2 on your agenda? I was out waiting for other members to show up.
We closed that item because the complainant has not responded to any communication for many, many, many months.
Okay, thank you. Couple of things. First, I want to congratulate the 6 of you for showing up tonight. But you are putting the complainant at a disadvantage by only having a quorum of 6, as you know. And also, unfortunately, the deputy city attorney is not here tonight, so that also creates some problems. So, in the future, if you know that you're only going to have a quorum of 6 and no the deputy city attorney, then perhaps you should put the matter on for another night. Secondly, you do have bylaws regarding absentees on the task force. I encourage you to read your bylaws and see what's considered excessive absenteeism, and then act accordingly. Finally, I've been waiting four months now for my complaints to be heard, and it's becoming extremely frustrating for me. You are putting me in a disadvantage as to having to recall the facts of matters that were 120 days ago. So, I just want to express my frustration in having to wait on what I feel are very important issues to me regarding transparency and open government. Thank you.
Thank you. Is there additional public comment? Okay, seeing none. Mr. Young, would you call the next item on the agenda?
Madam Chair, I just wanted to clarify on the previous decision for file number 14062. I did state that the complaint was, and the order that the violation was against the Department of Public Works. I did not mention any of the names listed in the complaint. I was wondering, did you want to list any of the people named in the title?
We should list the names, I think, that were in the, against whom the complaint was filed.
Thank you.
So, yeah.
File number 14069, complaint filed by David Eisenberg against Edgar Lopez, Paul Travis, and Frank Lee, Department of Public Works, for allegedly violating Sunshine Ordinance Section 67.21B, 67.24, 67.25A, and 67.34 for failure to respond to a request for public records in a timely and complete manner. I do have a letter in the file that has authorized Charlene Blitzley to represent the complainant.
All right, thank you. At this time, we need to take up the matter of jurisdiction. So has jurisdiction in this matter been listed? Jurisdiction? Okay, Member Oka, do I have a second?
Second.
Okay, Member Rummold. Any public comment on jurisdiction? Seeing none, without objection, we'll find jurisdiction. All right, at this time, I'm sorry, I didn't catch your name.
Charlene Bisley.
Bisley, okay. Okay, Ms. Bisley. At this time, you have up to 5 minutes to briefly summarize the case and also to bring us up to date beyond what we might have in our packet. Okay.
I'm Charlene Bisley. I'm standing in for David Eisenberg, who is currently on business in Indonesia. He is the owner of 2 chemical businesses, Microtracers and Resco Laboratories, both of which are located around the corner from 2111 and 2115 Jennings Street. He is very disappointed he can't be here himself today. So am I. I was only briefed on this matter recently, so I'll do my best. The purpose of Mr. Eisenberg's complaint is very similar to Jonathan Germain's complaint, experience, and grievances, except that instead of it being from the residential side, this is coming from the business side. David Eisenberg made an immediate disclosure sunshine request on June 29th to Edgar Lopez and Paul Travis of the Department of Public Works. On July 1st, he received a reply from Frank Lee of DPW that the DPW is withholding documents based on sections 6724A2 and 6724E1 of the Sunshine Ordinance. By the way, I do apologize for the deja vu, but there are a lot of similarities, okay. So bear with me. Mr. Lee explained that DPW was not asked to develop plans or limited plans for 2111, 2115 Jennings Street. But then he said that HSA requested merely a, quote, proposal from DPW for a, quote, possible project at 2111, 2115 Jennings. And that such proposal, as far as I know, he said, had not been accepted or rejected, and therefore no service had yet been provided. Nor did he know if an agreement were in place. He then released a few emails referencing the matter, but no proposal. Now, Mr. Eisenberg later obtained a copy of this proposal from another source. It is actually 38 pages of detailed information, including 11 pages of a memorandum of understanding, 4 on electrical requirements, 9 on environmental requirements, 3 on geotechnical requirements, 7 on structural requirements. You get the idea. All highly detailed information with cost estimates for all aspects of the project. Withholding just this document alone, in Mr. Eisenberg's words, caused irreparable harm, delaying his ability to fight this project. And it left him fearful that the DPW would not respond fairly to any future requests. Had he not luckily obtained this proposal from another source, he would have had substantially less knowledge and be far less equipped to stop possible illegal acts by the HSA. Those are his words. On July 2nd, Mr. Eisenberg responded to Mr. Lee, citing 6724E1 was misplaced. This section of the ordinance is to prevent a department from being forced to disclose information about RFP or RFQ bids while in the process of collecting and evaluating bids. It is not, however, intended to prevent disclosure when a department is acting as a contractor. The legislation clearly acknowledges two parties, the department and persons or firms seeking contracts. In this case, the department is DPW, and there are no bids being presented to DPW, nor does DPW have an RFP out on this project. So 6724E1 does not apply. 6724A2 is also misapplied. It is only relevant when representatives of the city are negotiating an agreement with another party. Here, the city is the only party present. There is no other party. Had this section referenced representatives between departments, then perhaps two city departments could be defined as two parties, but it does not. Now, note, even if this section were to apply, it would only apply to draft versions, not other documents, not other communications. So further, Section 6726 requires withholding be kept to a minimum, as we've heard earlier today. It states that you should mask or delete non-exempt information from requested records in order to quickly release those portions that are acceptable. So even if 6724E1 and 6724A2 were somehow both applicable, Mr. Eisenberg should have received documents with partially excluded information. In other words, something rather than nothing. Mr. Eisenberg says, quote, in no case should metadata, the information that a city employee has communicated with another city employee, and the date and time of such communication be excluded from a sunshine response. And yet this is what happened. Mr. Eisenberg then filed a complaint on July 25th, stating that the Sunshine Ordinance Task Force should find Edgar Lopez, Paul Travis, and Frank Lee in violation of the Sunshine Ordinance for willful failure to comply with the law. Also, that SOTF order the DPW to immediately release all public documents that should have long been provided, including records of oral communication, deleted emails, text messages, and emails made to or from personal email accounts, as well as department email accounts and other resources that were relevant communications on this matter. Finally, he asked with future immediate disclosure sunshine requests that this never happen again.
Thank you. Is there anyone here to offer facts and evidence in support of the complainant? Okay, seeing none. The respondent, you also have up to 5 minutes.
Frankly, for the Department of Public Works. Essentially, Mr. Germain and Mr. Eisenberg's requests were identical, and our response to both were identical. So my explanation is similar to what I said half an hour ago. So that's my conclusion.
All right, thank you. The matter is now with the task force. Do you have... Oh, I'm sorry, facts and evidence in support of the respondent? Seeing none. The matter is with the task force. Member Wolf?
Could the complainant please approach the mic? So you were here when we adjudicated on the previous case that has very similar aspects to it. If we were to rule the same way, is there anything that differentiates what you're asking for from what the previous complainant received?
No, I would just make one fine point. You were asking the earlier complainant what information he was missing that he wants. And part of that conundrum is we don't know what's out there, so how can I ask for something that I don't know exists? So I just wanted to be more comprehensive and say, since I don't know what other documents are being withheld, then in addition to the types that I just enumerated, it would be great to have whatever else is pertinent on this matter be forwarded to us. Who knows if there were other types of information that was relayed, in addition to the emails and the other things that I mentioned.
So all communication and memos related to the project is essentially what you're asking
Right,
for?
and any other types of documents that would be pertinent.
Great, thanks.
So we typically ask, and requesters ask for any and all documents and records, so maybe we can ask for the specifics as far as we know them and then include that catch-all. And both orders are, yeah. I'm ahead of myself, but is there any more questions? All right, at this time, Mr. Lee, you have 3 minutes to offer a rebuttal.
Our answer to Mr. Eisenberg and Mr. Germain were identical. We provided everything we had up until May 14th, the day before the site visit, to both parties. And we told both parties we're withholding the documents from May 14th to June 13th, which was when we were creating the proposal and submitting the proposal to HSA. Those are the only documents that we are withholding.
Thank you. At this time, the respondent has 3 minutes for any concluding remarks. Ms. Bisley?
I just wanted to point out that during the previous complainant's remarks, Jonathan Germain's, that I noticed Mr. Lee had said, well, you have the proposal already, and I just wanted to point out that, that was not through any thanks to the DPW, and I don't want to take credit for the fact that we happened to be privy to that information. That was information that Mr. Eisenberg expressly asked for and was refused. And also, just to reiterate what Mr. Germain said earlier, which is that this isn't applicable because they are not a private bidder. And lastly, what piqued my interest in what Mr. Lee had said earlier, since these two matters are so comparable, was simply that he didn't want to make it public because he didn't want to prevent other bidders from stepping in. So to me, I think that just speaks volumes.
Okay, thank you. Members, do I have a motion? Member Wolf.
I don't have a motion at this point, but I'm curious if there's a way that we can tie the two parties, the two separate complainants together to ensure that they both receive the information at the same time, in case they are competing interests and we want to ensure that one doesn't get the upper hand over the other.
And may I respond?
Vice Chair Hyland.
I think that goes past the purview of what we're doing here, but I think what we can do is perhaps duplicate the motion from before with all the different provisions of the Charter of 67 and just make the same order of determination. That's probably the best way we can achieve that.
Member Wolf.
I don't think that addresses, now the concern may be unwarranted because I think both parties may have similar interests, but it seems like a potential workaround would be for the public information to be turned over to Victor, who then gave it to the complainants, than simply telling them the same motion. Because that's my concern, is that if one of the complainants in these similar cases has a more better relationship to the DPW, then they could potentially release this information to one party before the other party and give a advantage that seems problematic. Now, I don't think we actually have that in this case, but it does seem like a concern to raise for future issues.
Vice Chair Hyland.
I see where you're getting now. I think the order of determination will have a time frame in which DPW will have to release that information to all parties, these two and anyone else that comes up before them. So hopefully that period, and perhaps Mr. Young can...
That would be 5 business days.
5 business days would be close enough. If one gets it on the 4th day, one gets it on the 5th day, I think that would, justice would be served there, and that's probably the best we can do in terms of timeliness, if that's your concern.
We would also be following up at the same Compliance and Amendments Committee.
They would come up together.
Yeah. They would be sort of in lockstep all along the way. I think your ideas are interesting, but...
Yeah, I think one way to inoculate against the potential is just in this motion to say to all parties who have requested, and then that turns the whole thing into, once they turn it over to one requesting party, they have to turn it over to all of them at the same time.
Vice Chair Hyland?
We kind of did that with the Sunshine Ordinance, if you think about it. And that's the rules they're supposed to be following in the first place. And this is an order of determination in a specific case. So I think the best way of handling this, and I'd be curious to see what the members of the public think, but I think we just duplicate the motions we had and just vote on that. I think that's all we can do.
Member Wolf?
Victor, do you have any thoughts on what we're discussing here from an administrative perspective?
Nothing specific, but I do not believe I can specify when. I specify 5 days. Within 5 days, I don't think I can referee who gets what on which day. There's no way I can do that. I can make the order within 5 days, but I'm not privy to how they are transmitted to the complainants.
Okay, so at this time, do I hear a motion?
I'd like to propose the same motion as item number 4, with the same details.
Is there a second?
I'll second again.
Member Oka?
That motion is to find the Department of Public Works. The motion is to find Edgar Lopez, Paul Travis, and Frank Lee, and the Department of Public Works in violation of Sunshine Ordinance 67.21B, 67.25A, 67.24A and E, 67.26, and 67.27. Public comment?
Okay, at this time, is there any public comment on the motion? Mr. Germain?
Okay. So I just wanted to note, I don't have any concerns about Mr. Eisenberg getting information more quickly than I do, and I don't think Mr. Eisenberg has any concerns about my getting information more quickly. The one other thing that I wanted to note was that I think it would be most useful in the order of determination if the responsibility for complying with the order remains with DPW, as opposed to giving the order to Mr. Young as an intermediary, because if they don't comply with the order, I wouldn't want there to be confusion as to whether Mr. Lee had not done what he was supposed to or Mr. Young had not done what he was supposed to do. It seems simplest if the responsibility for complying with the order remains with DPW.
It ultimately will, for sure. Sir?
Grisham again. My comment on this matter 14069, Mr. Eisenberg. I'd like to re-echo what Mr. Eisenberg's representative stated about basically how do we know what records to request when we don't know what records exist. I've made a number of FOIA requests to federal agencies, and I echo the concern expressed by Mr. Eisenberg's representative vis-a-vis how does the public know what records to request if the public has no way of getting an overview of those records. Federal agencies, in my experience, are familiar with that kind of request. I'm drawing a similarity because it's exactly the nature of my complaint. That's what I was asking for, an overview, an index. For example, because it's parallel to this and it's relevant, I know we're not there yet, but it's relevant. On Monday, June 9th, 2014, 12:15, for I think it was the second or third time, I'll tell you later exactly, I wrote to Mr. Lee for a, quote, description of the nature and form of the records you maintain for public access and transparency, including statistics, electronic data, and other documentation that would show, e.g., for example, a rise or fall in accident rates, the public right-of-way adjacent to construction sites, historical trends regarding permit issuance, violation, enforcement, rescission.
So let's make this directly relevant to this. Okay.
It's relevant because I had to go to into such elaboration because of the obfuscation, what I perceived as obfuscation, deflecting, not understanding. So they got that elaborate from previously. Can you just describe the records that you maintain? And it was deflective. So I'll go over that again, but it's relevant because that's exactly what I was asking for, and it was repeatedly deflected until I contacted Sunshine Ordinance Task Force, at which time the responsive documents were immediately produced. So that's my comment. I re-echo the objection of this member of the public to the problem of responsive agencies, the problem of not knowing what records exist in order to be able to be specific about which the records you're requesting. It's a whole discovery process in my experience, figuring out what records do exist. And this is an area, again, in my experience, that can be easily danced around by the responsible parties in whatever agency we're talking about and such disclosure matters, public disclosure matters. Thank you.
Thank you. Is there additional public comment on the motion?
I support the motion in part, but I'm disappointed that there was no discussion regarding 6734, which the complainant raised in the complaint. This is the Department of Public Works night, and so you want to deter them to not have 3 or 4 more cases on your agenda. It's obvious that there's a pattern in practice by the Department of Public Works. Task Force Member Hyland asked Mr. Lee if he got advice from the city attorney. The answer was no. Mr. Hyland, Task Force Member Hyland, should have asked him if the Department of Public Works solicited an opinion from the city attorney. And I guess the answer also there would be no. So it's clear that there's a willful withholding of documents, and that was alleged in the complaint. And if you want to deter city agencies and city departments from continuing the pattern and practice of violating people's requests for public records, you should have a discussion, either in this case or the next Department of Public Works case that's going to follow this one. One other thing, if the complainant in this case filed his complaint on July 26th, then the Department of Public Works is getting priority on the agenda of other complainants that have filed complaints before, because I filed the complaint 2-3 months before July 26th. So I'm asking myself, why is the Department of Public Works here tonight on a complaint on the July 26th? You're making it convenient for the Department of Public Works to come one night and you can hear all their issues. You shouldn't be providing convenience to the Department of Public Works. You ought to be providing a deterrent so they won't continue this pattern in practice. Thank you.
Thank you. Is there any additional public comment on the motion? Okay. Seeing none, Mr. Young, would you call the roll on this?
On that motion, Member Rummel?
Aye.
Rummel, aye. Member Winston?
Nay.
Winston, no. Member Wolf?
Aye.
Wolf, aye. Member Oka?
Aye.
Oka, aye. Member Hyland, Vice Chair Hyland?
Aye.
Hyland, aye. Chair Washburn?
Aye.
Washburn, aye. The motion fails by a vote of 5-1.
Member Wolf?
Now, does that mean that we can continue discussing and make a new motion? Is that what happens now, or is it done? What's going on?
You may make a new motion if you would like.
Member Rummold?
Well, I think maybe it would be better to address Member Winston's concerns with the motion, and maybe we could fix it.
My concerns with these complaints, I have no problem with the policy concerns. Again, it is with what underpins this complaint and the last complaint. I cannot find a registry for SF equality in the State Attorney General, in the State Attorney General's charity registry, nor can I find it in the Federal Registry on GuideStar. I'm concerned about the intent, about the motives behind these complaints. And if anyone could address that for me, I would be more than happy to hear it. But again, I can't separate that from the complaints that we're actually seeing here. And that's why I voted no on this. It is, I see this as something concerted. I also am, no, I'll just leave it at that. So if those concerns can be addressed.
Sure.
Vice Chair Hyland?
I appreciate your zeal as an investigative journalist, and I think that's might be driving this. I think the easiest way, what I found works for me, is just assume every complainant is just a member of the public. Simple as that. And I think, I think that's probably what's in our charter, in our mandate. I know it's hard sometimes to, and I remember when I first started, I would ask questions and kind of get into the story of it, but in the end, you have to step back from that and really, I think, make determinations on the charter and on the the Sunshine Ordinance.
Member Wolf?
I mean, I definitely see your concerns, but it seems to me that basically, like, if any given member of the public has access to it, then whoever's requesting isn't really our business. So if, like, a member of the Nazi Party wanted a list of all the temples in San Francisco and the city has that record, like, I don't want to turn that over, but it's a public record, and I think that who is asking this and why just can't enter into what we're doing. But the bigger concern I have now is that I think that if Ali keeps his vote, we should vote on the previous measure over, because I don't see a distinguishing difference between the two. And I think that if we have one complainant that is entitled to this information and one that isn't, it's clear they're already on the same, like, they don't have issues with each other, but it just seems problematic from a body perspective.
Vice Chair Hyland?
And I think, I apologize, I think I maybe jumped the gun by going forward with this motion. So, if we discussed it a little bit more, we might have fleshed this out and then been able to, make a more informed decision. So, and that's what's happening now, basically, which is good. But in future, Member Winston, if you're not ready to vote on a motion, just stick your hand up and say, hold on.
My apologies, I hadn't yet gone through that information yet.
Yeah,
but
no problem.
I should have brought this concern up for the first vote, but at the same time, it does, I understand the issues about disclosure, but my whole point of doing this is to put it on record, that information, and I feel like we're not being given all the information we need to actually evaluate this project and evaluate the requests about this project.
Okay, that said, I think one of the major charges of our task force is to determine whether various records, government records, are public. And once we make that determination, those records are public, and any member of the public, anyone, can obtain them for whatever reason. It may be for a reason we loathe, but, we would not be doing the job that we are supposed to do under the ordinance if we were to withhold information from someone because we don't trust their motives.
Understood. This is all about putting it on the record.
All right, so
I can place a statement from Member Winston on the record if you wish to provide something to me specific in writing or email. I will be happy to place it into the minutes.
Sure, I'll get that to you.
Thank you.
All right. Do we have a procedure for a revote?
I will just restate the motion. The motion is to find,
Don't we have to rescind the last?
we do not need to rescind it. We just take another motion. There's no need to rescind the vote.
Okay.
That motion fails, and we can issue new motion.
Okay, all right. Do I have another motion?
The motion is to find, excuse me, I'm just finding my spot, to find Edgar Lopez, Paul Travis, and Frank Lee and the Department of Public Works in violation of Sunshine Ordinance Section 67.21B, 67.25A, 67.24A and E, 67.26, and 67.27. On that motion, Member Rummel.
Aye.
Rummel, aye. Member Winston.
Aye.
Winston, aye. Member Wolf.
Aye.
Wolf, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. My assumption is this will be referred to the Compliance and Amendments Committee with a similar order to the file number 14062.
Right, these should move in, I think the members want this to move in, these two items to move in lockstep with each other. So,
Yes.
Okay.
I have that noted.
all right. So I think it's time for a break. So let's have, how about a 20-minute break at this point? We're doing well getting through the agenda, so it's time for everybody to regroup and have a snack and.
Okay.
We are in recess for 20 minutes.
All right, the Sunshine Ordinance Task Force special meeting of August 26, 2014 is called back into order at 6:09 p.m. Mr. Young, would you call the next item on the agenda?
Item number 6, file number 14067, complaint filed by Charles Grissom against Frank Lee, Department of Public Works, for allegedly violating Sunshine Ordinance Section 67.21 and 67.34 for failure to respond to requests for public records in a timely and complete manner.
We have to find jurisdiction, first of all. Has it been contested? Apparently not. Do I have a motion to find jurisdiction in this matter?
So moved.
Second.
All right. Any public comment on jurisdiction? Seeing none, without objection. At this time, the complainant has up to 5 minutes.
Good evening. Charles Curtis Grisham, Jr. First, it is not credible to me that Frank Lee or his superiors at DPW did not consult the city attorney's office in these matters, and I find the city attorney's office conspicuously and suspiciously absent from these proceedings. Asks task force, as previous member of the public did, to follow up on the bylaws about absenteeism as well. And regarding this matter, I've submitted the email exchanges between Frank Lee, myself regarding my request, and so it's all in evidence, and I hope you've had a chance to read them. I'm going to pick out the highlights, please, in 4 minutes, 20 seconds. The first time I asked, Saturday, June 7th, 2014, 12:41 p.m., recognizing it was Saturday and there was no city work being done, I requested, quote, preliminary to my submitting detailed requests under the SOTF for public records. I request that you provide me with a description of the class type, format, and nature of these records, those records maintained by DPW for public perusal. I said I ask for this guidance in order that I make more focused and effective requests, saving myself and DPW time and effort, thereby reducing costs and waste. Also, preliminary requests for public records Pertaining to my construction sites, I'm going to skip through it a little bit. I asked for all public records, including all email communications maintained by DPW. This is the first time I asked regarding 1, pre-litigation and so forth, 2, legal claims and so forth, 3, police reports and so forth, 4, reports and documentation regarding accidents in the past 12 months. On Monday, June 9th at 11:09 a.m., Mr. Franklin replied unresponsively. The first line was, "Our department does not accept claims." I had not mentioned anything about a claim. I was not filing a claim. I had asked for records of claims that had been filed against them. Does not accept claims against the city. That responsibility belongs to the city attorney's office. First time he referred me to the city's attorney's office. He mentions claims, indemnification, jurisdiction, but it was all red herring, obfuscation, misdirection to me, and I felt that he denied the existence of 1 through 4, items 1 through 4 in that request, and no request number was opened by Mr. Lee and no records produced. Second ask, Monday, June 9, 2014, 11:18 a.m. Quote from me, "Please describe the nature and form of the public documents for which you are a custodian," amongst other things I said in that email. In fact, the long form is I defined what I considered sites under DPW jurisdiction and something he'd hassled me over. And working from that definition, please describe the nature and form of the public documents for which you're a custodian that I may make my requests as effectively as possible and without undue delay, which there already had been undue delay, in my opinion. June 9, 2014, 11:37, Lee replied unresponsively. First line, "Our department issues permits for construction, public rights-of-way, and for the use of public rights-of-way for construction purposes." And the rest of his email was irrelevant, red herring, obstructive, other adjectives I've used in the past. Third ask, same day, Monday, June 9th, 12:15. "Can you please help me with a description of the nature and form of the records you maintain for public access and transparency, including statistics, electronic data, or other documentation?" June 11th, 2 days later, Lee replies unresponsively. "We considered your request." Assigned at 14/207. Cut it short, he responded with documents that I had actually, most of which I had forwarded to him a day or so earlier. And he makes this statement, which I believe is false. "We have no statistics, electronic data, or other documents that would show accident rates, public right-of-way adjacent to construction sites, historical trends regarding permit issuance, violations, enforcement, rescissions. Our department does not have a certificate. Our department does not receive, keep, or compile such information." I believe that's not true. He concluded that request, and with those unresponsive documents, the fourth time I asked, on Wednesday, June 11th, I quote from myself, "I spoke with Victor Young of Sunshine Ordinance Task Force. This morning he advised me to ask you for a," quote, "index of the records for which you have public responsibility. Provide me with a quote-unquote index of the records you maintain for public scrutiny. I believe my previous request made clear that this was the spirit of my initial inquiry, which you have been unable or unwilling to comprehend." On June 11th at 5:07 p.m., which is really quickly after this fourth ask, he coughs up the responsive documents, which included Department of Public Works procedure number 202.01.05, records retention storage policy, and other documents. And stated with that included his department's list of records, which I took to mean was also the index the term Mr. Young had advised me to use, as well as clearly the same thing I'd been asking for. And, and I also said to the previous statement, I flat don't believe your statements about the department not having those records. They weren't denied to me. He denied the existence of those records. I've been very specific about. So I'd ask the board to consider finding, frankly, in violation of section, as well as other things you may consider appropriate. Also, section 67.34, willful failure shall be official misconduct.
Sir, you'll have some additional time later, but I believe your time is up.
Thank you very much.
Okay. Is there anyone here to offer facts and evidence in support of the complainant? Seeing none, the respondent, Mr. Lee, you have up to 5 minutes.
Frankly, Public Works. We responded to Mr. Grisham as best as we could. We gave him what we had, and we can't give him what we don't have. What he's asking for is not under our jurisdiction. We do not know who does, and we referred him to places where we thought that might have something that he might need or that he might want. Regarding to Mr. Grisham's comment about providing the index of records, the departments are all familiar with the term index of records, and we actually have the index of records on the website, publicly available. When Mr. Grisham asked for that long description that he had, I'm sorry, but I didn't interpret it that way, did not know what he wanted, but when he contacted Victor, and I think Victor replied and copied me, and then I finally understood what he said. Oh, that's what he wanted, the index of records. That's fine. So we gave it to him. We gave it to him almost immediately, and all within the 10 days of that original request. So I failed to see any violations or withholding of any documents, but if the task force is willing to help us determine what documents he needs that we may have, we'll be very willing to turn it over.
Thank you. Is there anyone here to offer facts and evidence in support of the respondent? Okay, the matter is now with the, with the respondent.
No, sorry.
Matter is now with the task force. Members?
Okay.
Member Wolf?
Mr. Lee, could you approach the microphone, please? So just so I understand you correctly, you received a request that said, can you please help me with a description of the nature and form of the records you maintain for public access and transparency? And you're saying that you were not aware that that was a reference to an index of records?
Yeah, I wasn't. So, yeah.
What did you think a description of the nature and form of the records would have meant?
I wasn't sure. To tell you the truth, I wasn't sure.
Did you reach out to the complainant to try to understand what he had meant by a description of the nature and form of the records you maintain for public access and transparency?
I don't recall, but it all happened within those very few days, so I don't recall. It may eventually would have led to that, but his complaint went to Victor as soon as we responded the first time, within a day or two, so we never had the opportunity to even ask.
Did you consult anyone in the city's attorney's office as to what the complainant might have meant?
Task force, we don't ask for the city attorney's advice on all public records requests. If we did, we would not have time to do anything else. We have over 300 public records requests as of 2014 already. So,
no, I understand that completely. I'm just curious how a sentence that to me seems fairly obviously a list of what records you hold wasn't either, like, I understand that the complainant followed up independently and perhaps this would have been done and it was just further in your backlog, but I'm just really trying to understand exactly why a description of the nature and form of the records is not.
Give you a little idea of how we do this. When we do get the public records request, we respond. As you can see, we respond to Mr. Grisham almost immediately. Sometimes we do miss things, and I tell you, it doesn't happen often, but sometimes it does. I mean, we handle so many records requests, and they're not simple ones. They're sometimes so lengthy that we have to digest every single item. And sometimes we may miss one, but that's where the communication comes in. We send the reply back. Sometimes the requester will say, hey, you missed this, we meant this, and ask us. In this case, we didn't receive anything. It went straight to Victor, and then Victor contacted us. Or I don't remember how he did it, but I think I was copied on it, and then Victor said, just ask for the index of records. And I didn't even wait for him to ask me. I just gave it to him. So, I mean, sometimes it happens that we miss little finer details on a records request, but we try to respond.
Do you think that as a sort of general standard operating procedure, if you're not sure of the records being requested, that it would pretty much always be helpful to provide that record of...
We do ask. We do ask when it's not clear. We do ask, but like I said, sometimes we may have missed reading everything. And in this case, it sounded like we did.
Okay, great.
And then
Thank you.
we responded with what we thought, and then usually a follow-up would have been the requester would have said, hey, Frank, or somebody, you missed something. And then we would have had that dialogue and say, oh, what did we miss? But in this case, we didn't even have the opportunity.
Great. Thank you.
Members, do you have other questions? I have a question for Mr. Grissom.
Yes, ma'am.
At this point in time, what are you missing from the Department of Public Works that you have not received?
Oh, ma'am, nothing, because as soon as I mentioned Victor Young's name in the email and said I contacted him, he advised me to say the word index. As soon as that, then within under 5 hours, he supplied the index of records, the departmental policy. But it wasn't until the pressure of my having contacted SOTF was brought to bear. And so that's the answer to the question. I have more commentary at the appropriate time.
Well, so you got the index of records. That was what you were principally asking for. So you ended up getting what you asked for.
Yes, ma'am. After the fourth time I asked, at which time I included the information that I had contacted your body, your organization, the task force, and he immediately capitulated and submitted the responsive documents, which I believe he knew to be the responsive documents all along, and he had them close at hand, because he almost immediately responded with those documents attached, and they are very complete. That, as I said in my first email, is preliminary to my detailed request. That's my roadmap to the request I will be submitting, but not until I get it worked out how they operate with their public records requests. So my very first request failed, and it was a request for an index of the records, and I had asked 4 times, the fourth time involving SOTF. I believe Mr. Lee is intentionally misleading this body by saying, oh, he didn't know, he didn't understand. I think that's beyond disingenuous. I think that's willfully misleading this body, and I would like you to consider that. And I think I can prove it. If we go into this in more detail, and if I had more time, I'd read. It's not that he didn't have time to respond or reach out. He gave a lengthy response to my initial request, which I think all here.
We all have that, yes. You'll have an opportunity to say more. I was just wondering if there was any documents that you were missing.
No, he immediately responded with the appropriate documentation, which he had in his possession the entire time, in which I believe.
Microphone, please.
Okay, all right, thank you. Members, are there any additional questions? Okay, at this time, Mr. Lee, you have up to 3 minutes to say anything additional you'd like to say.
No, I do not have anything additional to say.
Okay, thank you. Now, Mr. Grisham, you have 3 minutes, up to 3 minutes.
Again, I'd like to point out, please, that the first time I asked, I detailed, one, for records regarding pre-litigation, current or pending legal claims against the city involving DPW in any aspect, legal claims, 4 items that I specifically requested for, and I do believe those records exist. So actually, ma'am, in response to your request, I did request specific records. I misspoke before. I requested 1, 2, 3, and 4 of that email that you see in front of you, and those have never been provided to me. All I have so far is an index of the records, the main thing I was asking for, and a copy of the policy and procedures of record and retention, and coughing up the information to the public in the request. And that does not include this lengthy back and forth of obfuscating, irrelevant, red herring, obstructionist, obtuse language that Mr. Lee used on me. An average member of the public would have given up and gone away. I'm convinced. I had asked 4 times. It was only when I involved the Sunshine Ordinance Task Force. I believe that it is not true that these records do not exist, And I would like to get to the bottom of that with the help of the Sunshine Ordinance Task Force. And you see also the Board of Supervisors have been copied on this as well, and the mayor. I think it's very important. I think it ties in with the other complaints that have been heard here tonight. There is a pattern of misconduct, I believe, on Mr. Lee's part and his supervisors. I believe he's being coached. He's the tool, and he's being coached by Mohammed Nuru, who he works directly for. As I've also said, it is a conflict of interest to have the public records custodian at the Department of Public Works also serve as the executive assistant to the director of the Department of Public Works. That just stinks. And his loyalty to Mohammed Nuru is going to trump his role and his responsibilities as a custodian of public records with the public's interest at stake every time. And I would submit to you that that situation should not be allowed in this city. In the last 46 seconds that I have, I'd like to reiterate that it was not a shortage of time, a lack of ability to respond. He could have reached out to me. It was very clear what I was asking for. No reasonable person could read this and think that it was not absolutely clear what I was asking for. I don't accept any excuse that he didn't understand. I think that's beyond disingenuous. I think that's intentionally misleading this, an official body of the city and county of San Francisco government. And he, a highly placed employee at a city and county agency, that I consider this an outrage, and I think that it's not about the timeliness or the 10-day. It's about the deceit, obstruction, obfuscation.
Thank you. Member Wolf.
I don't know what the procedure here is, but based on something that the complainant just said, I realize that I have an additional question. Can I?
Go ahead.
Sir, can you go back to the microphone? So you've had the index of records for a couple months now, and you've been able to parse through those records and identify records that you want, it sounds like. Is that correct?
Yes, including, sir, records that would have been responsive to those 1 through 4, claims, information, accidents, and so forth, are included in that index of public records.
Have you itemized that in any written document at this point?
No, sir. I was more interested in proceeding with the complaint so I could get the procedure worked out and hopefully have him removed as the custodian of public records at the Department of Public Works because he's not honest, in my opinion.
Well, we're just here to deal with your complaint and not the way that any department may do their HR side of things. That's outside of our purview.
Understood, but if you come back and say with a decision that he's in violation of willful misconduct, then I think that would impact his HR status at DPW, as well it should. I realize it's outside the purview, but I think it's a very serious matter. I don't think that public officials of any rank or description should be allowed to get away with the kind of mendacity that I believe I've proved with this email thread. It wasn't a shortage of time. It was not a lack of understanding. It was a lack of willingness to produce the records. And I've only just begun to delve into those records, the index of which was provided to me.
Right. I mean, I certainly understand that. Where I'm coming from is that it sounds like there's definitely a failure to act appropriately, but without the itemized, these are records that should have been provided in the initial request, it's harder for me to see a willful act as opposed to a negligent act.
Could I please refer you to my email, my initial request, dated Saturday, June 7th, admittedly a day off for city workers, 2014 at 12:41 p.m. It starts off, "Dear Mr. Lee, I've also been very polite to him throughout, even though I got more and more frustrated with him. I tried to be as polite as possible, using phrases such as, perhaps I could explain myself better." I enumerate 4 items there that are represented in that ultimate index that I got that were never produced to me. And I'm realizing that right now, actually, on the spot as I review this, because I have put it aside until it's sorted out who's going to be the public custodian of records there and how that procedure is going to work in the future after this case has been heard and decided. Because I think that if I went ahead now requesting information about how Department of Public Works goes about its business in the city, that I would get a similar runaround. And again, echoing other people who've had shared concerns here, I won't know what I'm missing because if they deny its existence or don't acknowledge its existence, then I'll never know it's been held away from me. So I think 1 through 4 is the answer to your question there. And the reason I haven't made any further requests is because I do not trust this person or his boss.
No, I understand that. Thank you.
Mr. Grisham.
Grissom?
Member Oka? Yes.
Are you telling me that you have... sorry. Mr. Grisham, are you telling me that I'm looking at this June 7th request. You itemize 1, 2, 3, 4. You have not received any of the information?
No
Please speak into the mic, sorry.
No, sir, Mr. Oka, I've not received anything responsive to those specific requests, only so far the index, but the index itself does, I believe, show the existence of records that would have been responsive to that, which were not provided.
Yes, I'm aware of the index. I've gone through it. So you're maintaining that you have not received what you requested?
In that regard, sir, I have not received a single responsive record with regard to 1 through 4 on that email there. Nothing. Only the index and the policy and procedure copy that I believe is also in the record.
Okay, thank you.
Yes, sir.
Can you, Mr. Grissom, can you tell me on what page of the record that 1 through 4 enumeration is? I can't find it.
Which email it's contained in?
Which email and which page in our file?
Well, I don't know about your file, but I'm very sorry. But and I agree it's convoluted. But my initial request, my first contact, Saturday,
7th.
June 7th.
I don't think we have that in our file, or at least I haven't been able to find.
I haven't been able to find it either.
Well, I definitely forwarded it with the caption. I requested, and I can show you here where I forwarded it to your SOTF and said, please enter this forwarded email with attachments, if any, as evidence, caption complaint 14067, and it's in here. So if it's not in your file, I apologize. I can produce it for you at any time that you desire.
I believe that Mr. Oka has stated page number as 255.
It's there.
Thank you.
That's Mr. Grisham's request to Mr. Lee.
I'm having some problems. Do you have it?
Through the chair?
Yes, Member Wolf.
Mr. Grissom, have you submitted these? I don't know whether it's actually relevant to your claim, but I'm just sort of curious. Have you submitted the same public records request to other city agencies that may be also in possession of these records?
No, sir, I haven't.
Is there any reason why you haven't taken that approach in case there are? I mean, in speaking from my own past professional experience in dealing with pending legal claims against other counties, not San Francisco, I know that there's like the city or the county clerk was always a great place to look through those documents. So I'm just sort of curious if you've thought of other places in case DPW isn't in possession of these. Who else might have these and whatnot?
Frankly, that's not my concern at the moment. I realize that there are probably other ways I could get these records, including civil action and other agencies that maybe you'd like to tell me who I should go to as an alternative source for records about DPW's issuance of permits.
Mr. Grisham, would you speak in the mic?
I was asking Member Wolf, he's curious why I don't go to other agencies to try to seek the same information, because the information pertains directly to DPW and its operations, and they're the primary source of that information. I don't think it should be incumbent upon me to go to every agency in town who might have that information, which is actually exactly what Mr. Lee was trying to get me to do, just sort of go away, go bother the city attorney. He handles claims. I wasn't bringing a claim. I was asking for an index of public records that this gentleman maintains. And those records may be available elsewhere in answer to your curiosity, but no, I haven't gone anywhere, and I don't think that's any fault of mine.
I
want the records from DPW. I want DPW to come into compliance with the Sunshine Ordinance.
I was not suggesting the onus was on you to do so. I was just trying to get a sense of where you were at in acquiring these records and whatnot.
Where I am at is making DPW compliant with, trying to make DPW comply with the law and deliver the records that they do have in their possession, according to their own documentation, which I eventually did get only after seeking assistance from Sunshine Ordinance Task Force and 3 refusals. Worse than refusals, I feel it was intentionally deceitful, as I've said before, intentionally deceitful, and I'd like to pursue that as much as possible, either with this body or elsewhere. But have I answered your question?
You have. Thank you so much.
Members, do I have a motion? Do we have a motion?
All right. I don't really quite feel empowered to make a motion at this point, but my issue is that it seems like there was definitely evidence of incompetence and potential willful negligence, but I'm not sure that we have all the evidence to prove the willful negligence, and I'm not sure if there's a way to rule on the incompetent side and keep it open around the potential negligence issues.
Member Rummold?
So I'm not comfortable. I don't think there's enough evidence to support a willful violation, but I do think there was a very clear violation of 6721C, which is the failure to assist a requester, right, in locating records. Mr. Lee suggested that it was unclear about what he was requesting, and perhaps, and as soon as Victor suggested that it was an index of records, he immediately complied. I think maybe if there had been that back and forth, instead of issuing a kind of no records response, if there was a bit more of an attempt at clarifying what records he was searching for, this all might have been avoided. So,
Member Wolf?
I'd like to suggest that there's also a violation of 67.29 to the extent that the index shall be sufficient to aid the public in making an inquiry or request to inspect, although the index itself apparently did meet the criteria, and I think that in order to be sufficient to aid the public, it needs to be presented at that opportunity when there was a lack of clarity as to what the complainant was requesting. This index was clearly a potential tool to help identify those documents, and I think there was a failure under 6729 to not raise the awareness of that document at that time.
Okay, Vice Chair Hyland, you had something to say.
I actually had a question for Mr. Lee, if you wouldn't mind approaching, Mr. Lee. This is just really a reflection on I guess, the whole night of cases and whatnot, and I'm just going to ask you point blank, when was the last time you had sunshine training?
Every 2 years.
So I'll restate my question. When was the last time you had sunshine training?
Sunshine, what was it, last year?
So you're compliant?
Don't recall, but it's every 2 years. And I took the latest one. It was over at the school building.
Okay. All right. Okay, that's all I needed. Thanks.
I have Excuse me, I have a question, Mr. Lee. So looking at the original request of June 7th, which you first read, I guess, on June 9th, that Monday, he was asking right off for the index of records, although he didn't use those precise terms, but then he lists 4 things that he wanted to know. And what was your response? He said he didn't receive those documents.
May I see that request? Because I don't even recall. There were just so many emails changing back and forth that I'm not even sure what was what.
Do you have a page reference on that request?
It's on 255.
Pre-litigation, current, and pending legal claims against the city involving DPW and any aspects. I believe I referred them to the city attorney's website. The city attorney's website actually say that they accept claims for against all departments of the city and county in San Francisco. So I told him that if he's looking for any of that, he should go to the city attorney's office to ask, because we wouldn't know unless somebody files a claim. So, legal claims against the city involving DPW and an aspect that in the past 12 months have been adjudicated, closed, settled, or otherwise concluded. Again, we don't settle claims. The city attorney office does that. Police reports from past 12 months involving construction sites under DPW auspices or involving DPW in any aspects. He's asking for police reports, so I suggested that you go to the police and ask for those. Unless somebody gives us a police report, we wouldn't have it, and we don't keep police reports. Reports and other documentation regarding accidents during the past 12 months that involve workers, members of the public, or other persons at the sites under DPW jurisdiction. We don't accept those type of reports. And we suggested to him to go to Cal OSHA, because Cal OSHA has jurisdictions over construction worksite and construction employees.
So when did you tell him that you...
Within the 10 days, I'm sure, but I don't...
254.
What was that? June 9th, 2 days. So I responded on June 9th.
Okay, thank you. Thank you. Excuse me, sir.
I didn't even see this. I mean, I'm just going by memory here, and this sounds like that's exactly what
We have it, yes, on page 254. Thank you.
Okay.
What you just explained. Once again, members, does anyone have a motion to make? Excuse me, we're deliberating here. Member Rummold?
I would make a motion to find a violation of 6721C for the failure to help identify the index of records after the June 9th email.
Do I have a second?
I'll second that.
All right. At this time, is there any public comment on the motion?
Okay, so my public comment is in 2 parts. I'll try to speak quickly because of that. So in an earlier part of today's meeting, Task Force member Ali Winston asked why I wanted access to public records. He then proceeded to vote against a complaint that was similar to mine, based not on the law, but on disapproving of the reason that I requested public records. That was improper. Mr. Winston asked during deliberations that I tell him more about myself before he would consider changing his vote. I'm not going to satisfy Mr. Winston's request for more information about myself because I do not believe that they are relevant to the work of the Sunshine Ordinance Task Force. The Sunshine Ordinance allows any member of the public access to public records. Who the member of the public is and whether a member of the Sunshine Ordinance Task Force agrees with their stance on an issue should not be part of the task force's decision or any member's vote. Mr. Winston's actions throw into question SLTF decisions where he is one of the members making a vote.
Point of order, Madam Chair. Is this on topic? This is about the motion.
This is about the motion on the floor.
Okay. I'll continue on. The second part, which is more relevant to the motion on the floor, the fact that the Department of Public Works is here for 4 different sunshine complaints indicates that there's a persistent problem with handling of sunshine requests at DPW. So far, this task force has found that DPW was in negligent violation of the ordinance twice today. I don't know what the decision will be for this upcoming vote, but taken together, DPW's persistent failures to adhere to the Sunshine Ordinance represents a pattern and practice of obfuscating and avoiding sunshine requests. I believe that this is a willful failure when taken together and needs to be addressed as an overall issue. Perhaps by bringing a motion to find DPW guilty of negligently violating the Sunshine Ordinance in Mr. Grisham's case.
Thank you. Is there additional public comment? No, it doesn't. You're a party to the matter.
How many negligent acts of malfeasance then accumulate to become a willful failure to act? I guess that's the issue in front of the task force tonight. I'm disappointed that you didn't find serious and willful. I would strongly suggest it, unless you want to see Mr. Lee back here again on more than one occasion. The complainant filed an IDR and wasn't timely responded to. Unless I missed some of the discussion, Department of Public Works violated the IDR. Your excuse for not finding a serious and willful was that there wasn't enough evidence in front of you. The complaint alleged these violations against 3 individuals. So perhaps if you had compelled all 3 to show tonight, you could have asked them questions to establish a pattern of willful violating the task force.
Excuse me. Mr. Piccarello?
Yeah, thank you. So I'm troubled that when a complaint alleges violations by 3 individuals, you allow only 1 individual to come and state their position with no discussion by the other 2 members who have not been here. So at a minimum, you should require the other 2 members, the other 2 respondents who did not show, to come back and explain their position as to why this gentleman is still waiting for documents in addition to the index that he did receive. Thank you.
Thank you. Is there additional public comment? Okay, seeing none. Mr. Young, would you call the roll in this matter?
The motion is to find violation of 67.21C. Member Rummold.
Aye.
Rummold, aye. Member Winston.
Aye.
Winston, aye. Member Wolf.
Aye.
Wolf, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes. Is there any order?
Well, I'm thinking this might go to EOT. Member Wolf?
I would like to suggest that it follow up with the one that what's the follow up on the complaint? What's CNA? Thank you. Because I think that there is a clear potential that there was willful negligence based on how many documents that are accurate to the original request the DPW is in possession of. And if that bears out, then that needs to be followed up.
Okay, well, that wasn't part of the motion, though. We weren't finding them in violation of withholding anything. We were finding them in violation of failure to help the requester. And so in that case, we can't, there's nothing for them to complete comply with right now. What we do have is a situation where DPW does not seem to have procedures in place or have the training requisite for the other two people who aren't here. So I think this could be, they're already coming to compliance and amendments. So I think they ought to, this is a matter for EOT. Vice Chair Eileen, who chairs EOT, what do you think?
I think I'd rather see this go to CNA first, maybe at the same time as the other two. And if we're not satisfied with the progress, then bring Mr. Lee and the other two people in front of EOTC. That might be a more economical use of our time in subcommittee.
Well, the thing, as I said, though, when we send a matter to compliance and amendments, we are asking the department or agency to provide something. They have to comply with the order by producing the documents, which it has to do in the other two cases, surely. But in this case, we're not asking them to produce anything. We're saying you were not helpful. And so
Through the chair, Mr. Grisham, if you speak out one more time, you'll be removed. Thank you.
So is that clear?
I understand what you're saying now. What I'm also hoping is that these appearances before CNA would certainly get the message over to them. I'm happy to see them in EOTC, but I think we're sending a pretty strong message. And in fact, I'm considering separate motion after this of willful, just to throw it out there, have it on the record. It might be worth doing at this point. I'd be curious to see what other members think of that.
Okay. So, all right, I am the chair here, so I can. Member Rommel?
I agree with what you're saying. I think our findings should be consistent with the remedy we order. So I think it makes sense to send it to EOT.
Member Wolf?
Is it possible to make a motion for willful and then table it before the vote so that the motion is still sitting there?
I'm not sure what you're saying exactly.
Like a loaded motion?
No. So that basically, as the situation moves forward in terms of resolving the actual complaint, that there is a motion for willful neglect that hasn't been proven yet, but then maybe this is just complete craziness. I don't know.
Okay, well, all right. So the other two cases that are going to compliance and amendments, okay, we'll learn more. We're giving them an opportunity to produce documents, and we'll learn more, and it could be elevated to that level of willful. Okay, I'm still thinking faulty procedures, miscommunication. Maybe I'm seeing this in too rosy a way, but I do know that we decided, okay, DPW, you have to produce these things. Okay, and so that's what we'll be looking at. If there's any issue there, then we can kick it back here and.
Okay, I'm just speaking from Member Highland suggesting that he may make such a motion, and I don't really I feel very much on the fence as to which way to vote on that, and I know I can't abstain, so I'm just kind of torn.
Okay. Member Oka.
Yes, is there any reason that the other two respondents are not here or named? And if not, why not? There are two other respondents.
Mr. Young, what can you tell us about
I believe
them?
he's talking about cases that we have previously heard.
No. He's talking about there are three people from DPW that are named in all of these cases.
I only see Frank Lee named in this one.
Oh, this is just Frank
The
Lee.
one we're hearing currently is Mr. Lee only.
Right, okay.
However, the department's only required to send a representative, and Mr. Lee is acting as the representative for the department.
Okay. It's the custodian of records.
Yes.
Okay.
Okay.
All right, so I'd like to send this to EOT, and then we're still open here for.
Would that, I guess the only thing I suggest is, can we hear that after you deal with them in CNA? That might make sense procedurally.
Yeah, that could be. Yeah, we could schedule it after.
May I ask what we will be doing at the EOTC meeting? What is our request that?
I think we'd like to know how they handle public records requests.
We would like a
And-
presentation on public records requests from DPW.
Right.
Written procedures on handling sunshine requests.
Okay.
Yeah.
Is there anything additional in this case before we move forward?
Is there any additional motion?
No.
Okay. This matter is concluded.
It's not concluded. It's referred to EOTC.
Okay. Well, it's to be continued at EOT.
Thank you.
Thank you, Mr. Lee.
All right.
Item number 7, file number 14065, Civil Grand Jury Report, Ethics in the City, Promise, Practice, or Pretense. I just wanted to make one or two statements concerning our proposed response.
Okay.
Following the instructions provided by the Civil Grand Jury, our response should state clearly in regards to the finding whether we agree or disagree. If we have any recommendations, we should state that we disagree or partially disagree. And so there will be slight changes to make in our response. And in addition, it was brought to my attention that the Civil Grand Jury requests a 6-month progress report. And in our draft response, we do list 1 year on several occasions. It is suggested that we may consider changing that to 6 months so that we can provide a 6-month report.
All right. So I spoke with a member of the Civil Grand Jury. She was, Ms. Schmid was here earlier and apologized she had to leave, but thanked us for all of the opportunities we've had for our own discussion and for public input. I explained that I was hoping that we would be able to approve this tonight and move forward with it. I didn't have it. I wasn't planning to put it on the agenda for next week. We have a pretty full agenda. We posted it a bit late. Member Hepner and I worked on this back and forth for many hours last Friday, I believe it was. And it was sent around to an interested parties list. Now I'm thinking maybe we should continue it tonight.
We are past the deadline.
We are.
Responses were due on the 25th to the Government Audits Committee. And also, we were supposed to respond today to the presiding judge.
Okay. All right. I was under the impression from the members that if we were a little bit late, it wouldn't be the end of the world. But so, okay, we need to move tonight. So, all right. I did have some input from Mr. Manette Shaw regarding our response about finding 11 and pointed out to us correctly that the state government code 34090 states, I have the language here somewhere that he left, but that public records are required to be kept for at least 2 years. So we need to reflect that in our answer and also point out that the administrative code 8.3 is incorrect, that it should state that records need to be kept for 2 years. So that needs to be changed. And that's the only substantive thing I've gotten. And then the other changes we need to make sure this is in the proper format and get it off to the judge right away.
Can we vote on that tonight?
I think we have to.
Okay. Based on the changes that Victor mentioned, do we make a motion? How does that work?
Yes?
I believe we can make a motion each item individually, or?
I would say on the whole. We've discussed this thoroughly. This reflects having listened. Victor listened to the tape. Lee listened to the tape. A lot of work. We think we captured. I hope you've had a chance captured the consensus of the group, the input from the public, but mainly the consensus of the group. I don't think we're saying anything wild and crazy here.
Agreed.
So,
on finding 11, it is my understanding that we will change agree partially to disagree partially.
okay.
We will be adding some additional language concerning the 2-year retention matter and the administrative code being incorrect in section 8.3.
Right. Mm-hmm.
And the recommendation, we will be selecting, I assume, item 3, which states requires further analysis, and then we will provide our explanation.
Okay.
We have a choice of 1 of 4 responses, and we would like, it would be best that we state exactly what our initial response is.
Exactly. Okay. So 3 makes sense. And then finding 12.
Finding 12. This is concerning departments failing to post their source of outside funding as required by the Sunshine Ordinance. I currently have that we agree with this finding. And I also have a statement concerning option 3 requires further analysis and with further explanation to be listed.
Mm-hmm. Okay. And 17A?
17A. 17A is concerning there is useful information in the calendars of city officials that should be readily available to the public. So I believe that we agree with the finding 17A. However, I have listed option 4 not warranted. I believe that is because we believe that the department should be posting it and not the task force. I leave that to your discretion.
Oh, you mean the departments rather than the Ethics Commission?
Yes.
Oh, okay.
Sorry.
All right. Yeah, no, that makes sense. And 17A?
B? Are we moving on to 17B?
Oh,
Mr.
17B,
Wolf.
I'm sorry, yeah.
Were we specifically asked to respond to 17A?
Yes, we were.
Yes.
Okay.
And in our responses, we are only responding to the ones they ask us to respond. We had lots to say about several others, but Lee and I decided to keep this as clean as possible.
Makes sense.
Yeah. So 17B?
17B, the finding, the jury found calendar entries that did not meet the law's requirements, particularly in listing the meeting subject matter and attendee's name. I have listed that the task force agrees with a selection of 3 requires further analysis with further explanation.
Okay. And 20?
Actually, I believe we do need to respond to 17C. Do not have that readily available. There is no recommendation on that. It is just a statement.
We weren't asked to respond to
We are not
secret.
asked to respond. We just want to make a response to the finding itself, whether we agree or disagree with it. There's no recommendation
This is
on it.
about the Board of Supervisors, right?
One moment, I will find the selection.
Because we have some bigger response.
17C states, the training currently provided to the Sunshine Ordinance, the training currently provided on the Sunshine Ordinance contains no material on keeping of official calendars as required by the ordinance. There's no recommendation for 17C, but there is the finding, a simple statement of agree or disagree.
Yeah, go ahead.
And I believe that your statement would be to agree with the statement.
Yes, okay, yeah. Please add that then.
Next on the list is 20 A and B. 20A, the mayor's office should establish a blue ribbon committee of experts and stakeholders in open government. I believe under 20A, you disagree partially and you will provide an explanation. And under the additional response, you would select item 3 requires further analysis.
Okay.
20B is concerning
The special hearing officer, independent hearing officer.
yes, special hearing officers. I believe you would select
Number 4.
you would like to select 4? I had a different one, but
Really? What's,
I just had requires further analysis. But if you would like to state 4, the recommendation
oh,
will
no,
not-
no, no, number 3, I'm sorry.
Yes.
Never mind, number 3,
requires further analysis and will provide an explanation.
right.
And I believe that is completes the list.
So you'll be able to,
I will try to create a draft with these responses, with taking this document, making slight changes to state the agree and disagreement, and I'll be changing anything that says 1 year to 6 months.
okay,
And I will provide a draft for your review.
all right.
And hopefully we'll get it out within the next few days.
All right, so, but tonight we can
can
vote to
vote
approve
on-
this as amended.
As amended, yes.
So do I hear a motion?
So moved.
Second.
Okay, is there any public comment on the motion?
I'll be quick. On recommendation 20B, you have the language that the recommendation requires further analysis. I agree with that. But then you say, although it may be neither warranted nor feasible, seems to me you're implying, you're prejudging and you're concluding before you even do this analysis. That language is not necessary and it should be stricken. There's no need to say that it may not be warranted or feasible. You're saying it requires further analysis, period. So do your analysis and then you come to your conclusions. Secondly, you have in front of you the mayor's response to the grand jury's report dated August 25th. Perhaps the task force members should read the mayor's response, and then you might have different responses to your responses, certainly regarding the mayor's role in terms of having ethics as a practice rather than a pretense. But I think it's a good idea to continue the matter because you only have 6 members here, and that it should be vetted by all task force members. Thank you.
Is there additional public comment? Okay, seeing none, Mr. Young, would you call the roll?
The motion is to adopt the Sunshine Orange Task Force response to the civil grand jury report. I believe that the chair is authorized to submit that response to the relevant parties on that motion. Member Romo.
Aye.
Rumble, aye. Member Winston.
Aye.
Winston, aye. Member Wolf.
Aye.
Wolf, aye. Member Oka.
Aye.
Oka, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes.
Thank you, everyone. Mr. Young, would you call the next item on the agenda?
Item number 8, file number 14073, proposed amendments to Sunshine Ordinance Section 67.29-5, calendars of certain officials.
All right, this was prompted from the grand jury report, and it addresses what probably was a complete oversight, a mistake, or somebody accidentally deleted something when they were drafting the Sunshine Ordinance. So I'd like to ask Mr. Nada approach, and since you're the one that supplied the draft and urged us to take this up and to tell us why we should move this forward, and importantly, if we decide to, how we should best proceed.
Well, I certainly agree that it should be moved forward. I don't think there's any question. And as somebody who sat in on the drafting of the current version of the ordinance, Prop G, that was particularly with respect to the supervisors' calendars, that was an omission. And as a matter of fact, when the task force in the past has deliberated on amending the ordinance, that's certainly something we've taken into consideration. My view is that on the substance of it, there is no reason to limit the Board of Supervisors to the list of the officials we add as far as who's responsible for creating and making a publicly available a calendar. I think all elected officials should have that requirement, and that's reflected in the draft that I've submitted to you. One officer or official I would add to that is the sheriff. And if there, some of you might think of some others as well, and certainly that's, if you do, certainly add their names, although there is in the language including but not limited to, and that should cover it. As far as how to go, that's a tough one. I mean, you're starting to deal with political machinations and who's going to be in favor, who's going to be against. As I think about doing this, I think about how to approach it just from the standpoint of political procedure. My suggestion at this point is take it to the Board of Supervisors publicly at the next Board of Supervisors meeting, and then after that, immediately after that, decide which of you will visit supervisors' offices privately. Visit all of them. See which supervisors are willing to carry this. And on the responses or non-responses that you get, be public with that too.
It is an election year.
Precisely.
Yes, it is.
Precisely. 5 supervisors are up for re-election, and 2 supervisors are facing each other in an assembly race.
Exactly.
And so it will be very interesting to see how, if at all, they respond to this.
Yeah, if nothing else, this will be very interesting. And, it'll enable us to sort of test the waters for more amendments on that.
So at this point, go through the language that you see before you, see what you want to put forward, and then go for it.
Okay, thank you so much. Members, Member Wolf.
I'm totally in favor of this adjustment, and I'm basically in favor of either approach to it. I just want to really speak to the fact that if we do this immediately, there are certainly going to be people that perceive us doing a political act based on the election. If we wait till after the election, the argument that this is political goes away, but the chance of being successful also decreases.
Yeah, I agree. Other members?
Well,
Member Oka, what do you think?
you know, it depends on what kind of relationship we have with the board. I mean, I said last time that I have good working relationships with most of the members of the board, the current one and past ones. However, this is going to be, to get them to all buy into what we think they should be doing is going to be tricky. So I don't know if each of us should try their own supervisor or I'm open.
Member Vice Chair Hyland.
I had a question that perhaps former member Nee could answer, but maybe you can as well. If we got some groundswell for this and some support, what would be the mechanics? Would they propose this a motion in the full board and vote on it? Is us bringing it to them going to require them to vote on it? How would this pass through the machines of City Hall, I guess?
Well, not being a city attorney, I really couldn't tell you. I think definitively Mr. Young might actually be more qualified than I on that, since he works for the clerk of the board and I think has in the past clerked for a number of the committees. But my off the top response would be that the task force is bringing this to the board does not trigger a requirement that the board act on this at all. They can say thank you and then shove it aside and forget it.
Yep.
They can also say thank you, and somebody might bring it before the board as a motion, and then the president of the board says, okay, I will assign it to thus and such committee, and the committee just sort of pigeonholes it saying, oh, well, gee, we'll get around to it as soon as we can. That could happen. And there are all kinds of possible scenarios out there. And with the chair's permission, I'd like to respond to Mr. Wolf's remark about the question of whether this is political and whether the task force could be accused of politics on this. The matter has already been addressed by the grand jury, and if anybody accuses the task force of politics on this, all you have to say is, well, gee, the grand jury has already suggested this. We're merely following the suggestion of the civil grand jury. Mm-hmm. Politics removed.
I don't know if it's ever possible to remove politics, and frankly, I think politics is a fun sport. I'm looking at this as being interesting and fun. So that's my 2 cents.
Regarding the mechanics?
Yes. Oh, please. Yeah.
I would assume that we would get one of the city attorneys to draft the resolution. Hopefully Mr. Cola can draft the amendment to the administrative code for us. Then we could provide that ordinance to a member of the supervisors to introduce on behalf of then, of course, the president would assign it usually to the Rules Committee or one of the other committees. Upon hearing that, the committee would refer back to the board for vote. If the committee does hold it, it is possible to call it out of committee. The sponsor can call it out of committee.
Mm-hmm. Okay.
But I would say it takes, if everything goes quickly and smoothly, it'd take about 2 months.
So now, does any of that preclude say me from going to the next Board of Supervisors and in public comment saying, hey, this is what we plan to do?
You can speak on any matter at public comment of the Board of Supervisors as long as it's not on their agenda. However, a member of the supervisors would have to officially introduce it.
Right. So it might be something we could kind of alert them to, get some public interest and still lobby.
Or when the Government Audits Committee hears the civil grand jury report, that might be an opportunity to comment at that meeting.
Oh, okay. That would make sense. Right. That'd be
Guarantee to have a meeting within the next 30 days.
Okay.
Introduce it then.
Right. That'd be perfect. Member Wolf.
I'm just curious why it seems more beneficial to raise it in that sort of a context and then try to find the supervisor to introduce it as opposed to pass this, find the supervisor, and try to make this as smooth a process as possible as opposed to creating. I mean, either way, they're going to hear about it from this meeting, so it doesn't even really matter. But
Just
Vice Chair Hyland.
Just thinking between the lines here, going back to an earlier suggestion, if we float this to a supervisor that might like to run with this, especially given that it's an election year, and have someone introduce this as their motion, that might be an interesting way of doing it. Have them champion it, and think about who that might be, or which persons that might be. I have some ideas.
Okay, I do too, but I'm thinking we could do all of the above. We
Yeah.
can, I think, Rick Neese' suggestion that we're doing this in part because of the civil grand jury report. So if we appear at the meeting where the matter is brought up to them, that would be a logical place, but that doesn't preclude us from going to a supervisor and saying, and feeling them out to then be the person who introduces it, right? Does that make sense? Yeah. Okay.
I probably should have mentioned that the Government Audit and Oversight Committee does expect a member of this task force to appear at their meeting when they do discuss the civil grand jury report.
Okay. All right. So it'd be the Government Audit and,
Oversight Committee.
okay. And who's on that committee?
I don't have that list at this time. I can provide that to you.
Okay. All right, so at this time, do I have a motion to move forward with this?
What does moving forward look like?
Oh,
I
having,
assume that the motion would be to request that the city attorney prepared an ordinance to implement the change suggested by Member Nee. Once that draft is ready to go, I would assume that a member of the task force would ask one of the members to submit the ordinance for review by the Board of Supervisors.
and at the same time, at the appearance before the Government Audit and Oversight Committee on the civil grand jury report, that we would mention this. So do I have a motion to do those things?
So moved.
A second?
Second.
Any public comment?
Yeah, I'd like to thank Mr. Nee for the suggestion on his draft. I'm in favor of expanding the calendar requirements. Although it appears that the initial draft is much broader than the grand jury was recommending, and the language is very vague regarding some of the criteria as to who is a public official. So perhaps the city attorney, deputy city attorney, can give you a draft. Secondly, I agree with Member Wolf. I think you need a supervisor to run with your idea. Ideally, Supervisor Campos would be the ideal supervisor to run with this proposal. He might even use it as a wedge against his opponent, sunshine and not being sunshine. So you would want to target Supervisor Campos. Perhaps he's listening tonight. Finally, again, though, the proposed draft is very vague, and it wouldn't stand constitutional muster. It's so vague as to who's an official and what their roles are. So have the deputy city attorney present a draft to you that would be permissible in a court of law, and then have Supervisor Campos run with this idea. And perhaps you would want to use it as an election issue. Thank you.
Thank you.
Task Force members, Richard Nee, respectfully, I disagree with the vagueness description. I believe the language in that I have proposed states all elected officials and department heads. I think that's fairly clear. And then there was something else right at the tip of my tongue, and it must have been important because I'm forgetting what it is.
You're sounding like Mr. Warfield. It's tough on that side of the mic, isn't it?
Can be, yes. Thank you.
All right. See nobody. Any additional public comment back there? No? Okay. Mr. Young, would you call the roll?
On that motion, Member Rumbold?
Aye.
Rumbold, aye. Member Winston?
Aye.
Winston, aye. Member Wolf?
Aye.
Wolf, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Hyland?
Aye.
Hyland, aye. Chair Washburn?
Aye.
Washburn, aye. The motion passes.
Okay.
And through the chair, I mean, all respect to Mr. Warfield, I just thought that was interesting.
It was all in good spirit.
Yes.
Okay. Would you call the next item, please, Mr.
Item
Young?
number 9, Sunshine Ordinance Task Force meeting schedule. I have provided a meeting schedule in the packet listing the dates of each of the meetings for the remainder of this year. I did note that November 25th and December 23rd are holiday issues, and maybe we should just cancel those now instead of listing those. That would be November 25th is Thanksgiving week, and December 23rd is 2 days before Christmas.
So those would have been special meetings?
Yes.
Okay.
All right.
That would be, yeah, I'm not going to be here the week of Thanksgiving.
And I have listed the meeting dates for all the subcommittees. I was informed that there may be issues with the other special meetings. If you wish, I can send out a poll to all the members to see if they can attend the September 23rd and the October 28th meeting. And I could provide a report concerning those days to see if we want to go forward with those meetings.
Yeah, if you would.
Yes.
Yeah.
And I will, upon your approval, I'll consider this schedule finalized for the next 6 months or for the remainder of this year.
Could you email me that separately?
Yes.
Or, yeah, since I don't print out my packet. Well, thank you. All right, there we go. Could you call, any discussion about our meeting schedule? Okay. Next item on the agenda? Oh, wait, I'm sorry.
I mean, I think that we should cancel the 25th and 23rd, as Victor talked about, but we haven't explicitly said that one way or the other. You just said that you weren't going to be here the week of Thanksgiving.
Oh.
That is at the call of chair. If you would like to make that, cancel those meetings at this time, I will note it.
I'd like to cancel them, yes.
Yes. The November and December special meetings are canceled. And I will issue a poll concerning the special meetings of September and October.
Now, what does canceling these meetings do to our attempt to deal with the backload? The backlog.
I will have a more detailed report next week on Wednesday with my administrator's report.
Okay, thank you. Yeah, we're working some angles here to try to deal
At the
with
risk of being unpopular, should we not table the idea of rescheduling them for different days that month, or is that just too hard with all the subcommittees going on?
Why don't we talk about that next time?
Okay.
I think once we figure out the backlog problem.
Yes, I believe there's still the issue of, I did send a copy of the letter that I sent to Anonymous, and I believe that until we contact her, I don't plan to schedule any of her items until we can contact her and work out a plan to hear her items.
Okay.
And just out of curiosity, the next EOTC is September 8th. Is that what we've got penciled in?
I just lost my copy, but
No.
I believe it is November. Yes, there's the EOTC in September. I'll be sending you a draft agenda for the
Yes.
September 8th meeting.
And November 10th is the next one. Got it.
Yes,
Okay.
I'll be sending you that draft tomorrow. There are a few outstanding issues.
Great. Thank you.
Yeah, members, the special meetings business, they're special, so we're trying to get rid of them quickly. All right. So if we could move on to item number.
Item number 10,
Okay.
approval of minutes from the August 6, 2014 meeting.
Move to approve.
Second.
Any discussion? Any
Public comment?
public comment on the minutes?
Yeah, just a correction on my public comment. On page 622, it says I suggested that the members not trust the opinions of the attorneys and perform their own research. I think what I meant to say was that they should not defer deliberations to the opinions of the attorneys and perform their own analysis. So if I misspoke, I'm trying to correct the record. Thank you.
Thank you. That sounds much better. Okay. Anything else? Okay. Did you get that? Mr. Young?
Mr. Curlo, would you mind repeating that? I did not catch all of it.
Certainly. I don't think I said don't trust the opinions of the attorneys. I think I said don't defer to the opinions of the attorneys and to do their own analysis. Rather, yeah, I trust both attorneys on this task force.
Thank you.
Okay, thanks.
Okay.
On the motion to approve the minutes as amended, Member Rummold?
Aye.
Rummold, aye. Member Winston?
Aye.
Winston, aye. Member Wolf?
Aye.
Wolf, aye. Member Oka?
Aye.
Oka, aye. Vice Chair Hyland?
Aye.
Hyland, aye. Chair Washburn?
Aye.
Washburn, aye. Item number 11, announcements, comments, questions, and future agenda items.
Member Rummold?
That one case that I wrote up, the police inspector case from 4 meetings ago or so. I sent it out to folks, and I thought we were going to put it on the agenda for this time. Maybe it's next time, but I just thought I'd raise it again.
Could we put it on for next time?
For the third?
Yeah.
Yes.
I don't know. I don't know what to do with it.
Okay.
But I figured at some point we should talk about
Well,
it.
we were all mystified by some things, so
Right.
anything light you can shed on it would be good. I just wanted to let everybody know that next time we need to get that final report, our annual report, out the door. So,
If you want that included into the packet, I would need it to have it by Friday morning if possible. And there is one suggestion concerning the cover letter that I received from the clerk of the board. I will hand it to Mr. Highland and
Okay, so Vice Chair Hyland and I will work back and forth then.
And you need that?
by Friday morning, so I can include it in the packet for next
Okay.
week's meeting.
All right.
And there was, I'm forgetting now.
Okay.
Is Friday enough to include it in the packet?
Yes, I issue the packets on Friday afternoon.
Okay. Oh, okay.
Happy birthday.
I'd like to work on Wednesday.
Let's get it done by tomorrow. How's that?
Okay. It's my Medicare birthday, no less.
I see.
You're supposed to all say, I can't believe you're.
I know.
I do recall, this is probably for the EO, from the last CAC meeting, I did receive 2 requests to reconsider the decision. We do not have a procedure in place concerning how we handle requests to reconsider complaints. There is a rule about what we can reconsider, but not a procedure. My thought was that I would send a copy of that request to all members of the task force, and if anybody would wish to have a hearing to reconsider, they can send me a response requesting that we have a hearing, and I would schedule it. Otherwise, I would make the assumption that none of the members wanted to take up that issue. That is following the model of the Board of Supervisors.
Yeah, if you could outline the procedure when you.
Yes, I will bring it forward next week with the administrator's report.
Okay, thank you. Do I hear a motion to adjourn?
So moved.
Okay. Thank you.
Anything box. Anything box.